For the introduction of unlawful assembly, unlawful assembly is the act of gathering 3 or more people in order to cause disruption in public. This is a disrupt order by the people in order to cause harassment in public as well. The goal of this unlawful assembly is to provoke and cause violent execution towards the innocent people out there. If there were no proper actions taken against them, this could turn into a mob. And with the coercive and violent execution caused by them, this could turn out to be a public disorder. In order to solve this, certain penal codes has to be taken down against these people. Thank you.
Firstly, by referring to Article 10 Clause 1b of the Federal Constitution, where all citizens have the right to assemble peacefully and without arms. But Article 10 Clause 2 mentions that they have right to assemble peacefully, but restricted to certain extent. It is under the principle that human beings are not always right in the use of their rights. In the case of Nik Nur Hafizi by Nik Ibrahim and others versus Public Prosecutor, the High Court held that even though citizens have right to assemble peacefully, but still subject to the Article 10 Clause 2, 4 and also Article 149 of the Federal Constitution, which give Parliament power to enact law for security and public order. It was stated Section 27 of Police Act 1967 as constitutional and valid. This freedom is actually not a question of right but rather of privilege in nature. The Penal Code also provides punishment for whoever involves themselves in unlawful assembly. Section 143 and 151 of the Penal Code states that the punishment for a member of an unlawful assembly and for the continuing the unlawful assembly, even as to disperse, shall be punished with imprisonment up to 6 months or fine or both. Section 150 of the Penal Code states that any person involved in hiring, engaging, or employing persons to take part in an unlawful assembly shall be punished as to the same as for a member of such assembly and for any offence committed by any members of such assembly.
Previously, we discussed the punishment for a member of an unlawful assembly. But when more than one member is involved, we will look at the common objective where every member of an unlawful assembly will be deemed guilty of any offence committed in prosecution of common object. A case to exemplify this point is the case of Muhammad Haikal bin Muhammad Khatib Sadali and others against public prosecutor, where the appellants killed a member in their school during a fight, but the identity of the person who delivered the fatal blow was not confirmed. The court held that it was a joint liability asserted under Section 149 of the Penal Code because they had common object of causing grievous hurt that will likely cause death. Moving on, Section 159 of the Penal Code defines affray. To constitute an affray, there must be a fight between 2 or more persons, the fight must be in a public place, and the fight must disturb the public peace. According to the case of Aden against public prosecutor, a fight happens when blows are exchanged in a bilateral transaction. When there is a fight in a public place, there is disturbance of the peace. No further proof by the prosecution is necessary. If a person is attacked by another in a public place and he makes no retaliation, he cannot be guilty of fighting in public. Accordingly, no quarrelsome or threatening words will amount to an affray.
Statutes that also mention about unlawful assembly can be found under Criminal Procedure Code and Police Act 1967. And there are 2 sections under the CPC, which are Section 83 and Section 84. Section 83 states that it is the obligation of the magistrate and any Gazette police officer not below the level of inspector to provide notice to disperse an unlawful assembly. And Section 84 states that if members of an unlawful assembly refuse to disperse as directed by the person in power, the armed force may do whatever it takes to disperse the assembly. And the case of Siva Segara against public prosecutor can be further referred. Moreover, in regards to Police Act 1967, it mandates that any public assemblies, meetings or processions receive a permit from the police and is not prejudicial to the security and peace of Malaysia. And the section which we can refer is Section 37, Clause 1 and Clause 2. And the case of Murugan anak lelaki Munyandi against public prosecutor can also be referred further to see the application of the section and how the application of Police Act 1967 play a role in regards to unlawful assembly in Malaysia.
For Peaceful Assembly Act 2012, we shall first refer to Section 9 subsection 1 where an assembly notice is required to be given, a public assembly is taken to have complied with the requirements under this Act after the giving of the assembly notice, which then leads to subsection A, which states that an acknowledgement notice of the public assembly is received by the organizer of the public assembly from the OCPD or his representative. Section 9, subsection 5, on the other hand, will criminalize the organizer who fails to give a tender notice prior to the event or gathering that will be held. Section 15 in this Act lays out the guideline and also the terms that must be adhered to by the organizers and the participants to the assembly in order to make the assembly legal and also peaceful. In the case of Nik Nazmi bin Ahmad against public prosecutor, the appellant was charged for organizing an indoor public assembly without notifying the officer in charge of the police district 10 days prior before the event, as stated in Section 9, subsection 1 of the Peaceful Assembly Act. They have also notified the police district on the very day itself of the assembly when it was held. They had also argued that both Section 9, subsection 1 and subsection 5 of the Peaceful Assembly Act should be struck down as they were ultra-vires with the federal constitution for having totally prohibited a spontaneous or immediate assembly, and it was unreasonable restriction on the constitutionally guaranteed right of the citizens to assemble peacefully, and it was legally and constitutionally wrong to criminalize its breach. Thus, in this case, the court had allowed this appeal.
In conclusion, there are certain procedures and penal codes that could be taken against these people. Special authority given to the police and public as well as the magistrate in order to catch the people and put them into the bus. Not only that, the members of unfull assembly could face a few codes under the statute of penal code. Thank you.